Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Yeah. The FTOE is in, it should have completed amended. I don't know why it was never shared, I guess because it was just an FTOE.
All rise. So report back in session.
Thank you. Good afternoon. Please be seated. Yes, ma'am.
That's my approach briefly.
Yes, ma'am. I need to pull up Zoom also.
23 CF 782. I don't see Mr. Longshore yet. Anthony Lucy. No, Mr. Lucy, if you'll come down to the lectern. 23 CF 736. Good afternoon, sir. Mr. Lucy, the charges are driving while license suspended with prior convictions and attached tag not assigned. Does the state have an offer for Mr. Lucy?
Yes, Your Honor. It would be an adjudication of guilt, 2 years of probation, 615 court costs, community service in the amount of 48 hours, and that would be the offer, Your Honor.
Okay. So, Mr. Lucy, the reason why I asked for that is because of the charges against you. I didn't know if it was something that you may want to accept without an attorney. Have you ever been on probation before?
Yes, sir.
Okay.
I don't stand to do that.
Okay. And have you ever been adjudicated guilty of a felony?
I don't think I have.
Okay.
I
Do you want me?
want to check real quick, Your Honor, because I would amend it to a withhold, Your Honor,
Okay.
the offer, so that he's not adjudicated.
Okay, so what the state's offering is a withholding of adjudication, 2 years probation. If you say, I don't want to do that again, then I'll ask you if you want me to appoint a public defender if you qualify financially.
Yes, sir.
Okay, how much money do you make per month?
It's 12, I think.
Okay, I do appoint the public defender, Mr. Klein's approaching on your left.
Thank you.
Your Honor, did Mr. Lucy enter a plea yet?
He did not.
Okay. We will acknowledge receipt of a 2-count information, waive the formal reading, enter a not guilty plea, and just ask that this remains set on the July 10th docket.
Okay, Mr. Lucy, I'll see you on July 10th at 9 o'clock. If the state offers you something that you want to accept before that date and you want to avoid about 300 defendants, talk to Mr. Klein's about setting a hearing before then, okay?
All right.
Thank you, sir. Mr. Klein's, other than Joshua Longshore, I don't think there are any other pro se's.
Yeah, thankfully not. There's a lot of represented. So,
Alan Sudo.
thanks.
Oh, I'm sorry, they're not all in order, are they?
No.
Gotcha.
Sudo. S-U-D-O.
Oh, Mr. Sudo's right.
Good morning.
Good afternoon, yes, sir. 23 CF 839. Does the state have an offer for Mr. Sudo?
So withhold of adjudication, 12 months probation, 615 in court costs, a public defender fee if applicable, substance abuse evaluation within 30 days, and begin any recommended treatment in 60 random year analysis and 12 hours of community service.
Okay. Mr. Sudo, you have the right to represent yourself if you want to accept the state's offer. Have you ever been on probation before?
Not back here. I was in probation back home.
Okay. So you have some idea of what it
Yes.
relates to. If you want your case to be disposed of today, it'd be a withholding of adjudication, 12 months probation. You'd have to pay the court cost, submit to a substance abuse evaluation within 30 days from today. If that evaluator said you needed to have treatment, then you'd need to begin that within 60 days from today. You'd have to submit a random year analysis and perform 12 hours of community service work. If you say, I don't feel comfortable doing that without an attorney, then I can appoint an attorney if you qualify financially.
I can take the state's offer.
Okay? If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down. Thank you, sir. So do you understand, if I accept your offer, that you're waiving your right to a trial by jury?
Yes.
Okay. You're also waiving your right to an attorney. Do you understand that?
Yes, sir.
Okay. Have any questions for me or the state?
No, sir, not at the moment.
Okay. Mr. Sudo, I do accept your plea. Adjudication is withheld. You're sentenced to 12 months probation. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You'll need to pay you'll need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment within 60 days from today if it is required. Submit to random urinalysis and perform 12 hours of community service work. Okay.
Yes, sir.
Thank you, sir. And probation, do you want to talk to Mr. Sudo now? Yes, sir. Thank you.
Sir.
Glenn Von Fintel? 23 CF 735. Good afternoon, sir. This is Von Fintel?
Von, sir.
I'm sorry, say it.
Von Fintel.
Fintel.
Von Fintel.
Get it. Von Fintel. Got it.
Yes, sir.
Okay. Thank you. Does the state have an offer for Mr. Von Fintel?
Judge, the offer is the same as the last defendant that we just had.
So withhold of adjudication, 2 years probation.
12 months probation.
I'm sorry, 12 months.
$615 in court costs, substance abuse evaluation within 30 days, and begin any recommended treatment within 60, random urinalysis, and 12 hours of community service.
So you heard what I said to the previous defendant. Have you ever been on probation before?
I have.
Okay. You have the right to accept that if you want to. You have the right to an attorney if you qualify. You have the right to an attorney no matter what. You can hire one privately, or I can appoint one if you qualify financially. You have the right to a jury trial if you want. What would you like to do?
I like an attorney.
Okay. How much money do you make per month?
It all depends, man. I'm just starting a new job, so.
What have you average making per month?
It's
over
somewhere
the
around
last-
$2,000.
Okay. I do appoint the public defender to represent you. Mr. Kleins is approaching the room.
Okay. Jason McKinney's going to I want you to fill it out, turn it into the clerk's office downstairs.
You fill out.
You could ask, how much is your third vacation home? If you don't have a third vacation, I'll just put 0 or anything. Okay. Your Honor, we do acknowledge receipt of a 2-count information, waive the formal reading, enter a not guilty plea. Ask that this remain set on the July 10th docket.
Yes, sir. Mr. Von Fintel, I'll see you on July 10th at 9 o'clock. If the state offers you something that you want to accept before that day, Mr. Kleins can set a hearing, okay?
I appreciate it.
Thank you, sir.
Should I do this reference? Yeah, you can prove it in the courthouse if you can.
William Vordenbaum?
Yes, sir.
Vordenbaum? Let's see here. Jonathan Wilkinson? See Mr. Wilkinson? I skipped one, I think. Dyray McMullen, 23 CF 750. Thomas McMullen. I'm good, doing well. How are you? Does the state have an offer for Miss McMullen?
Hold on a moment, Your Honor, I'm pulling it up. Your Honor, there's kind of a twofold type of thing. If she has an adjudication and wouldn't mind taking another one, there would be an adjudication of guilt and credit for time served. If she does not have an adjudication and would not like to take one, we would offer a withhold with 2 years of probation, $615 in court costs, a substance abuse evaluation within 30 days, and any treatment recommended within 60 days, 24 hours of community service work.
Okay, so Miss McMullen, have you ever been adjudicated guilty as a felon?
Nope.
Okay, so what the state's, they're offering you, so you're only offering her the adjudication of guilt and time served?
No, there was two options, Your Honor. There was the adjudication of guilt and credit for time served,
Okay.
or
And the withhold, even though she's previously been adjudicated guilty?
didn't she just say she hasn't been?
Oh, okay, I missed that, I'm sorry.
Uh,
Okay, so Ms. McMullen, you got a few different options. One is if you want to be adjudicated guilty of a felony, you could be sentenced to time served. Good, I think that's a good response. Have you ever been on probation before? Okay. Do you want me to appoint the public defender if you qualify financially? How much money do you make per month?
11.
Okay, I do appoint the public defender. Mr. Kleins is approaching on your left. Don't go anywhere. Yes, please.
I want you to fill that out, okay? Turn it in downstairs to the clerk's office, answer every question on it, though, even if it's 0 or not applicable. Just put in not applicable. Your Honor, there is a one-count information. We'll waive the formal reading, enter a not guilty plea, and ask that this remains set on the July 10th docket.
Ms. McMullen, I'll see you on July 10th at 9 o'clock, okay? Thank you, ma'am. I think that's all the proceeds. At least I've gone through them once. Mr. Kleins?
Hillary Marion, followed by Amanda Martin.
Thank you.
I'm sure I'll screw it up.
Hello, Ms. Marion.
Yeah, this is Ms. Marion, who will acknowledge receipt of the one-count information, waive the formal reading, enter a not guilty plea, and ask that this remains set on the July 10th docket.
Okay. Ms. Marion, I'll see you on July 10th at 9 o'clock. Stay in touch with Mr. Kleins, okay? Thank you. Amanda Martin. Hello, Ms. Martin.
Hello, how are you doing?
Good, how are you?
Looks like that'll be followed by Jocelyn Serrano. And this is Ms. Martin. Here's the one-count information. We will waive the formal reading, which are not guilty plea. And ask that remains set on July 10th.
Okay. Ms. Martin, I'll see you on July 10th at 9 o'clock.
Yes, sir. Thank you.
Thank you, ma'am.
Just ask. No, I get that. I know you did. Oh, there it is.
Spanish?
Need an interpreter?
I needed to do another one after.
Okay. Is Teresa inside in the courthouse? Do you know?
Yeah, I don't have any interpreter in that.
Okay. Then if you'll just sit in the gallery, I'll call you in a few minutes.
Okay.
Thank you.
Devin Spears. Yeah, it looks like Mr. McKinney's indicated he filed a written not guilty plea.
For Spears?
Spears.
I don't see Spears.
Okay.
Okay.
So I guess just leave that on the July 10th docket.
Yes, sir.
Valerie Spiller.
Hello, Ms. Spiller.
Your Honor, this is a direct issue caveus. It is a one-count information. We will waive the formal reading into a not guilty plea and ask this remains set on the July 10th docket.
Ms. Spiller, I'll see you on July 10th at 9 o'clock. Okay. Thank you.
Call office before then. Stephen Spradlin. Stephen Spradlin. Mason Stepp.
Hello, Mr. Stepp.
How are you?
Good, how are you?
Good.
Good.
Steve's not willing to. So, Your Honor, this is Mr. Stepp. There is a one-count information. We will waive the formal reading into a not guilty plea. Ask that this remains set on the July 10th docket. There is a credit for time served offer in this. The problem is that it carried adjudication. So, depending on what Mr. Stepp and Mr. McKinney discussed, you might see Mr. Stepp back before you. Not too soon.
Okay.
Not too long.
So I'll see you back here no later than July 10th at 9 o'clock. Those your folks that came with you, or who came with you?
Yeah, these are my people.
Good. Thank you. Thanks for being here for Mr. Stepp.
Thank you.
Yes, sir.
Jordan Wims. Just the phone. Your Honor, this is Mr.
Servillo.
Servillo. Is it Wims? Servillo?
Wims Servillo, yes.
This is Jordan Wims Servillo, Your Honor. We do have a one-count information. We will waive the formal reading, enter a not guilty plea, and ask that this remain set on the July 10th docket.
Okay. I'll see you back here July 10th at 9 o'clock.
Okay.
Thank you, sir.
William Zaremba. I believe there's a written not guilty plea for Mr. Zaremba on file.
Yes.
And we would just ask that this remain set on the 7/10 docket, but it looks like this might be a PTI, so probably beforehand. Robert Zollner. Your Honor, this is Mr. Zollner. You have one count information. We will enter a not guilty plea and ask that this remains set on July 10th docket.
Okay. Mr. Zollner, I'll see you back here July 10th at 9 o'clock. Stay in touch with Mr. Clients. Okay?
All right, thank you.
Thank you, sir.
Say that.
Allison, anybody, I know that one young lady is Spanish speaking.
This one is Spanish speaking too, but I don't see it on my docket, so I'm gonna make sure. Can you translate it for me? His case was dismissed. His case is dismissed.
Appreciate it. Have a good one. Oh, here's a card. See, Mr.
Now we have this.
Okay, I'll see if I can hold that up.
No, that's for,
Yeah, it's the same contact. Yep.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
The desired language.
Spanish.
I understood Danish. If this is correct, say yes or press 1. If this is incorrect, say no or press 2.
no.
Please speak the name of the desired language.
Spanish.
I understood. Finish. If this is correct, say yes or press 1. If this is incorrect, say no or press 2.
Yes.
I think that was finish.
That was finish.
Oh, then we don't want to finish.
Yes.
Yeah, but
Language solution.
If they say yes, no, which language do you need?
Spanish.
Thank you. May I please have your access code?
access code.
Hold on 1 second, ma'am.
Yes, ma'am. Take your time.
It's 222-000-103.
Thank you. Please hold for the sponsorship secretary company.
Thank you.
Please hold for an interpreter.
Danish, twice.
Thank you for calling Language Line Solutions. This is Andres, ID 386-335. I'll be your Spanish interpreter today. Is your customer with you, or do you need me to call them for you?
Yes, sir, she is here.
Buenos días, seré el intérprete en esta llamada.
Can you ask her to talk into the microphone?
¿Podría hablar en el micrófono, por favor?
Está bien.
So, Ms. Serrano, my name is Scott Kleins. I'm your attorney.
You need to talk.
Yeah, I was going to say.
Thank you. Yes, sir.
Can you please tell her, Ms. Serrano, my name is Scott Kleins. I am your attorney.
Mi nombre es Scott Klein, yo soy su abogado.
She's here today for an arraignment, so that's just where we're going to enter a not guilty plea.
Estamos hoy aquí para la lectura de cargos y vamos a entrar en declararnos no culpables.
Okay. So I'm going to acknowledge receipt of a 2-count information and enter a not guilty plea.
Voy a recibir los recuentos y entrar en la declaración de no culpabilidad.
Okay. Her next court date is going to be July 10th.
Próxima fecha en la corte será el 10 de julio.
Okay. I'm going to ask her to write down her phone number on my file.
Le voy a pedir que escriba su número telefónico aquí en el sitio.
Can you please tell her that I will call her with an interpreter and we can talk on the phone before July 10th?
Le voy a llamar como un intérprete para que hablemos por teléfono antes del 10 de julio.
Okay. If your voicemail is not set up, please set it up. If it is set up in full, please empty some of it out so I can leave a message.
Si tu correo de voz, pero su buzón de voz no está configurado, por favor, hágalo. Y si está lleno, por favor, borra algunos para que pueda dejar un mensaje si es necesario.
Does she have any questions?
¿Tiene alguna pregunta?
No.
Mr. Kleins, if you'll make sure it's 9 o'clock on July 10th, if you'll tell her
Yes.
that, you didn't say it was 9.
Understood. Can you please tell her that the court date is 9 o'clock in the morning on July 10th?
La fecha de la corte es el 10 de julio a las 9 de la mañana.
Okay.
The last thing, Mr. Klein, if you'll ask the interpreter to explain to her why we were laughing because of the finish, just where she is.
Absolutely. Can you please tell her that nobody was laughing at her? When we were trying to get in the language line, the judge kept saying Spanish and it kept going Danish and then Finnish, and it was just ridiculous. And we were kind of laughing at the system, definitely not laughing at her.
Sí, también para que sepan, no nos estábamos burlando de usted, sino que fue cuando quiso llamar al intérprete, decía español, danés, fino, entonces era ridículo cómo funciona el sistema para escoger el idioma. Entonces, no era usted, sino era él.
And we'll enter a not guilty plea. I don't know if I did that.
Okay. Yes, sir. Thank you. Thank you, ma'am.
Thank you.
Thank you so much, language line.
Bye.
Have a wonderful day.
Thank you, you too.
Talk to Ms. Richardson. Ms. Richardson? Yes. Okay. You want to do Odom real quick? Okay.
I'll take Odom and Robert is going to be. Good work, everyone.
Isn't this one of the cool?
You take mine.
That's fine. So this is the last one. One year in probation. Okay. But it's going to be supervised by JCS, not state probation. So this is misdemeanor probation. Okay. And then court close. All right, that's yours. Go ahead and sign and date this real quick. Your Honor, this is Mr. Odom. We have reached an agreement to resolve this. Today's 5/11. On count one, Mr. Odom is going to be pleading to the lesser included offense of refusal to obey a lawful command. Count two is going to be the plea as charged. The agreed upon sentence is that Mr. Odom will be placed on a year of probation concurrent between the counts that will be supervised by JCS. He'll be assessed misdemeanor court costs and $150 in public defender fees, and will be adjudicated of those misdemeanors.
And then it's $50 a month, JCS fee, right? Yes, sir. Thank you, sir. Mr. Odom, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. So, Mr. Odom, what you may not have heard when you were speaking with the bailiff is there's the court cost, $150 public defender's fee, and JCS charges $50 a month for the supervision fee. Okay.
Yes, sir.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Correct.
Mr. Odom, I do accept your plea. You're adjudicated guilty of the misdemeanors. You're sentenced to 1 year of probation, and that's concurrent, runs at the same time between the two different counts. Probation will be with JCS. You'll need to pay the court cost, $50 per month cost of supervision, and $150 public defender's fee. Okay? When you came out, you smiled and gave a thumbs up. That's why the administrative judge for our county changed it and had the judge for your case doing these versus having a county court judge do it, because we accomplished a lot of things. So I appreciate that. It's nice to have it resolved today.
As well, I feel.
Yes, sir. Thank you. The statute number, Mr. Klein?
I'll have to look that up. Failure to abide by lawful command. I'll get that to you once I talk to Ms. Richardson.
I have Stephen Rogers next.
Okay, thank you.
I may need a moment with Ms. Davis before we begin on this report. I'll ask Ms. Davis before we begin. She had mentioned she might want to have the probation officer here to testify. I don't know if she's got an answer.
Yeah, my understanding is that it's fine.
So we can proceed today?
Yes, sir. Yes, sir.
All right, Judge, let me finish up. I was finishing up Mr. Briones' paperwork. Gathered my materials from Mr. Rogers. Again, I'm sorry. I don't want to delay us. But I have in front of me the plea agreement from Mr. Rogers. It's not an agreement. It just contemplates a plea to the bench. Elucidates his maximums. I'll just pause for him to sign before we begin.
Okay.
I haven't signed it yet, sir.
Okay. Did you read it?
To the charges of probation, admission to the charge. The only thing that I don't understand is
the right to have the judge decide whether the defendant violated the terms of probation. That's what we're doing right now, correct?
Right, you're admitting the violation.
But I'm waiving my right for him to decide whether that I violated or not.
Right, because you're not going to an evidentiary hearing.
Oh,
You're admitting the violation.
understood.
May I approach, Your Honor?
Yes, sir. Mr. Rogers, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Let me do some preliminary things with you, and then let's talk about the substance of it.
Yes, sir.
Are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
I was supposed to seek the treatment from Ridgeway, but no, I'm not. Not that I'm aware of, sir.
Okay. So you were supposed to be treated at Bridgeway.
I was given 30 days to complete a drug assessment and a mental health eval.
Yes, sir.
Because of the indigent circumstances that I found myself in upon my release from jail, I came out with nothing to go to, and I went from basically living in our car. Me and my girlfriend, Jamie Wiggins, we were residing in the car. We went from there to the hotel on CBS.
Okay, so
I understand. I understand. It's going to.
And then I'll let you tell me the other list of
okay.
things. How far did you go in school?
College.
Okay. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Most of it, yes. I mean, there's some. Not knowing the vocab, he kind of cleared it up with the judge being my.
Right. So here's what I see. We call it a plea straight up, or
Yes,
a plea to the bench.
Plea to the bench.
So there's no agreement with the state.
Correct.
And you could be sentenced up to a maximum of 6 years in prison, 5 years on count 2, 1 year on count 1.
Yes, sir.
That's your biggest downside. Also, $6,000 in fines. Do you understand that?
Yes, sir.
Okay. Do you have any other questions about the plea agreement?
The only other ones was the fines. It was $7. Well, before this violation, I owed $760 to the court cost fines and fees. Term of the probation with constant supervision was waived. My belief was that when those character references were filed, half of my court cost fines and fees were also paid. I don't know if that happened yet, but it can happen as soon as I am released. I can pay half of the $760, not the $6,000.
Yes.
He's just telling you.
Okay.
Oh, okay.
I just want you to know your maximum downside.
Okay. Oh, that's the maximum fine that I can pay. Okay, I didn't know.
Okay.
Simple.
I just want you to know the downside, the possible downside.
Right.
If you say, "Yep, I
I
want to go forward," I have no idea what I'll sentence you to because I haven't heard from you or the state.
Correct.
But I just want you to know the maximum. Okay?
Thank you, sir.
So did you sign the plea agreement?
Yes, sir.
Okay. Do you have any questions for me or your attorney or the state just about entering the plea?
No, sir.
Mr. Rogers, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you and are represented by competent counsel. Are you satisfied with your counsel's representation?
Yes, I am, as a matter of fact.
I do find that there's a factual basis for acceptance of the plea, so I do accept the plea.
Thank you, sir.
So as far as sentencing, we doing it today? We doing it some other time?
Please.
I believe Mr. Rogers would like to do it today. If the state is prepared to go forward today, I think we are. My only issue on the front end was there was some character letters submitted to the court file 2 days ago. The state has said they have no objection with the court reviewing those letters, considering the same. I've brought some copies if the
That'd be
court
great.
has not had an opportunity to review them.
I have not.
All right. One is from one Jamie Wiggins. Another is from one David M. Severance. Am I pronouncing that correctly? It's my understanding he has unfortunately since passed away since the writing of this letter. And then the other one, it does not have a name, but remind me, Mr. Rogers, who this one is from?
Chief Stan Wiggins, Jamie's father, fire chief.
Good. Yes, sir, please. Okay, yes, sir.
All right, and without objection from the state, Your Honor, I'd like to move those documents into evidence in defense one.
Yes, sir, they're admitted into evidence.
Thank you, Your Honor. And I'd like to take some testimony from Mr. Rogers.
Okay, Mr. Rogers, you're still under oath.
Would you like him to stay next to me, or would you like me to come up to the witness stand?
If you want him to stay there, he can.
It doesn't matter to me, whatever the court would prefer.
Yes, sir.
All right, Mr. Rogers, would you state your name, please, and spell your last name for the record?
Stephen Joseph Rogers, Rodgers.
And you're here today to admit your violation and accept a sentence in your VOP today, correct?
Correct.
All right, and I want to talk a little bit about your violation. The primary basis for the violation is the positive drug test. Is there anything that you would tell the court about your positive drug test in this case?
I got overwhelmed and kind of self-medicated. It's the first time in my life that I've actually had, like I said, my ducks in a row and was moving in a positive direction. It wasn't like a rewrite. I just needed to get some stuff done and just had to focus on Mr. Severance's house, the landlord's house that needed to be remodeled, and was trying to kind of weed through bad decisions and kind of fell back on old habits, if you will.
The next primary allegation in your violation is the failure to complete this treatment and evaluation. Can you tell the court a little bit about what happened with that?
Yes, sir. The three basic needs, food, shelter, and clothing, kind of happened at my release of coming out, and not from going from nothing to something took a little longer than I anticipated. I did get to Patterson Group, I believe is the name, on Vine. After filling out a phone book stack paperwork that they had me fill out, they asked for $100. I had not made the paycheck that I needed to cover that at the time that I was at Patterson Group, and it was on, I kind of procrastinated with it. It was towards the end of the 30 days, and they needed $100 for the eval, and I told them what the probation office told me to tell Bridgeway, that the cost of supervision was waived, so there's some they said some terminologies of pushing it to get the eval in, and then payment can be, I guess, they could bill me or something. Patterson Group did not agree to that, So I took the same packet to Bridgeway thinking that they would just take the packet. Well, that's not their packet. I had to fill out another packet. And then they told me that their earliest was a month and a half out. They gave me another packet to fill out. And of course, it took me like an hour to fill out the other one. And it was pushing 4:30, 5 o'clock by the time I made it to Bridgeway. So I just took the packet, kind of filled it out as much as I could there. They closed the doors and I went home with the packet. The packet should be filled out, or I just never got a chance to get back on that side of things because Mr. Severance lives on Woodham and I'm on a bicycle. My girl's got a flat tire at the moment. And anywho, it was just indigent circumstances befell me again, and that's when I kind of resorted on old habits and kind of wound up. It's been about a year since my last incarceration. I think I noticed that June 23rd was my release date, and I've been able to make it from then until now without getting any kind of trouble, and it's my first violation with no new charges. I just don't see the extreme that the state was going towards, and that's why I was just kind of I'm looking for. I do admit to needing help. I don't. My childhood wasn't the best, and I think I deserve the opportunity to have an outpatient
Let me direct you with that.
Diagnosis.
Mr. Rogers, as to your reference letters, talk to the judge a little bit about your relationship with Mr. Severance and what happened there.
I met Mr. Severance about 2 months ago. It's been I was about 2 months ago. I was about a month, or on probation for about a month, and I ran into Mr. Severance, and he was on the heavy side, if you will, obese to be exact. He couldn't do the work himself, and the people that he had found to help him didn't know what they were doing. They didn't have. I don't even know how they put two boards together. If you saw some of the stuff I witnessed as far as the construction, he wasted $80 to $125, depending where he bought the materials at, $1,000 on an addition that has to be completely torn down and redone because nothing's to code. From the joists to the tie straps on the roof. I saw this instantly walking up, being a man of construction. I grew up with my dad, Rogers Paint Drywall and Paint Drywall Incorporated. And after he got incorporated, I grew up on the job site, and I tried to stay away from my dad and found a plumber and an electrician to learn something else other than paint and drywall. So I'm not licensed myself, but I know that that's not right. Just looking around, and he needed help. And as the character references, I was touched when he said I showed up at Mighty Mouse.
Yes, sir. That was when I smiled when I was reading.
He was a good man, and here recently, this past weekend, he got involved in a car accident. Apparently, he ran a red light on 87. Left a 9-year-old child fatherless, and then later didn't make it through the night. And there's people at the house right now that have stolen his wallet. He wasn't even taken out on a gurney before they were stealing his stuff and taking it to the pawn shop. I just heard that when I talked to Miss Wiggins on the phone 2 days ago. She didn't want to tell me all the confusion that's going on at his house right now because she knows how I get. And
Mr. Rogers, let me ask you a couple of questions.
Yes,
Did you
sir.
say that you were released from the Okaloosa County Jail on June 23rd?
That's the last time I sent a text on the tablet is when it was somewhere around.
But then you were only on probation for the last few months?
My sentencing hearing was in January, I believe, is when the state was asking for 9 months, and Mr. McKinney said, "Do you want to do a trial by juror, or do you just want to plead to the bench?" And I looked at I thought about it in my position. I mean, if I was a juror, I would.
Okay, you answered. I was just curious how long you were out.
Right. Thank you. It
Let me
was.
get back on. That's a good time to segue to Ms. Wiggins. Talk to the judge a little bit about your relationship with Ms. Wiggins.
Okay. Me and her have been together for the past 5 years, going on 6. She actually, I believe, took the stand at my hearing and gave testimony to what I've been going through and what I've been through. She's a fire captain from Texas for 12 years. Her mom had cancer, and she came over here. Within 6 months of being here, we met, and we've pretty much been inseparable ever since.
You rely on each other?
Very much so. Very much so.
Anything else that you would want the court to know to make a good decision in sentencing today?
I just want the opportunity to help myself instead of, and Mr. Severance and Ms. Wiggins to an outpatient facility, modifying with conditions with curfew.
Do you feel as though if the court were to order a curfew, that's something you'd be able to abide by?
Yes, sir.
If the court was to order house arrest, you could feel as though that's something that you could abide by?
Without Mr. Severance, I don't know how I'd pay it. Not at this time. I mean, I have some avenues and resources, but right now I could.
You just mean in terms of your housing, you don't know how you'd afford the housing.
Right. I don't know how.
But if the court were to order community control and probation needed to know where to find you,
oh, yes.
probation would know where to find you.
Correct.
Okay.
Correct.
Understood. Anything else that you'd want the court to know?
May God bless you in all things you do, Your Honor.
Does the state, do you have questions?
No, Judge.
Okay. Any other evidence? No. Mr. Marlowe, argument?
Yes, Your Honor, briefly. We're asking the court to reinstate his probation. If the court sees right to reinstate the probation, we're asking the court to impose any conditions that they see necessary to ensure compliance with Mr. Rogers in the safety of the community, whether that be enhanced supervision, drug offender probation, a curfew, or even community control. We believe Mr. Rogers is still a candidate for that. He does score 39 points and a bit of change. He does not score mandatory prison. It is permissible. But we're asking the court not to sentence him to prison today. If the court does see right for further incarceration, we would ask the court to consider a county jail sentence and revoke and terminate the probation. But we are of the belief that Mr. Rogers is a candidate for supervision, that this represents a stumble, and that he should be given another chance, Your Honor.
Okay. Thank you. To the state?
Judge, Mr. Rogers has been before the court frequently, so what I think Your Honor probably remembers, and I think in some of the testimony that Mr. Rogers was mentioning, probably just jogs a memory, because Mr. Rogers had been released on a signature bond, and then he failed to appear for court the immediate next court date. So then he had written the court. You can look in the records, you can see he wrote the court at that point and said that, oh, I was evicted, things were just messed up, and so the court withdrew the capias. So then we come to court, we end up getting set for trial, and on the eve of trial, Mr. Rogers enters a plea to the court for methamphetamine that was in his pocket. So where he had been telling the court the whole time that it wasn't his. So then we come in for sentencing in January. He is late to court because at that point, I know he mentioned that Ms. Wiggins had a flat tire today. His testimony at that point was she had a flat tire that day. This has been a theme going on about, so I just want some of the testimony from Mr. Rogers to be taken with a little bit of a grain of salt. He comes into court today and tells the court that it was just this stumble. He was working so hard. Well, he wasn't truthful with his officer. He told his officer that he didn't take anything. So he could have told his officer at that point that that's what happened. This could have been a different scenario. And this has just been an ongoing thing, looking through his history from other cases as well of absconding, failing to report, not being truthful with the officers. This has been ongoing all the way through his other cases. His other cases have always ended up in a revocation and a county jail sentence because Mr. Rogers never does what he's supposed to do. He's been supposed to do multiple evaluations. He's never done them. This court gave Mr. Rogers a break in January, let him have the ability to do probation with the same things that he's purporting to the court today as his reasoning of why he needs to be on supervision because of his financial status, of this, of that. We went through this exact same scenario when he testified and Ms. Wiggins testified in January. Same exact thing. And the court gave him that opportunity and told him at that point he had a short leash of doing this probation. And we're talking within 3 months that he has violated with positive drug tests. So apparently he can afford drugs, but he can't afford to do a Bridgeway evaluation that the court asked of him, as well as a mental health evaluation that the court asked of him. So it just, at this point, Your Honor, you gave him the opportunity to be successful on probation. Mr. Rogers, yet again, chose not to be successful on probation. At this point, with his actions and with his regard for probation and for this court, the state would ask for a 12.1-month DOC sentence.
Thank you. Mr. Morrow, finally.
Your Honor, the reason why she knows so much about my past and is so very on point with pretty much everything is she represented me before when she was a public defender, which is crazy. But I'm not disputing the conflict that even permits.
Let me stop you a second. What happens in that regard, Ms. Davis? If he says there's a conflict because you previously represented him?
There's nothing that I have represented to the court that has anything to do with any prior information that Mr. Rogers has disclosed to me. What I have purported to the court is things that are within benchmark, and you can see the documentation of benchmark. It was things that I actually, looking at this, the last case that I'm referencing was a case with Ms. Deering. That's the one that I was looking at. I never represented him. It was after I left the public defender's office. It has nothing to do with my representation. What would become a conflict is if I was giving the court information that I had obtained through my representation of Mr. Rogers. That was a case, and the information regarding his prior non-compliance with supervision is from a violation of probation report from a case in 2020 when I had already been gone from the public defender's office and Ms. Deering represented him.
I've never been
So
on
you feel
probation.
comfortable ethically that you can continue to prosecute Mr. Rogers?
Yes, Judge.
I was sentenced to
Mr. Rogers,
probation in 2012.
Hold on, Mr. Rogers.
And Heather King was
hold on.
not Heather King.
I do have concerns about, protecting the legal system. All
Right,
we've got
correct,
is
correct.
the power that we get. It does concern me what you're raising as far as the conflict.
Correct.
And I need to be clear for the record, Your
Yes, sir.
Honor. This was raised with me, and Mr. Rogers assured me that he wanted to waive that conflict and move forward with that sentencing
Correct.
if there was a conflict recognized by the court. So I want to
Thanks, Mr.
put
Morrow.
that on the record right now.
The conflict is that
Okay.
she represented me prior to
I understand.
2021 and knows my file beyond as a public defender and has used testimony
Okay,
from
hold on,
previous.
Ms. Davis, so absconding, failure to report, that was all from, that wasn't this case, right?
No, Judge. That was a case that Ms. Deering represented him on.
Okay. Okay, so I don't find a conflict as far as that.
Correct.
Mr. Rogers, you do a really good job of advocating.
Thank you, sir.
The state does a good job of advocating also from their perspective.
And
Wait, hold on, it's my turn to talk.
I'm sorry, sir. The tire was
What?
flat in the driveway. For real. My
Previously, Mr. Rogers was just on regular probation, but he had to go to the substance abuse evaluation and those things, correct?
Correct.
Okay. Because, Mr. Rogers, if you were asking me to do the same thing that I did before,
No, sir.
not going to do that.
No, sir.
Okay. I don't have to do a downward departure. I can modify supervision without that, even if you did score prison.
Thank you.
What is the current term of supervision or probation that Mr. Rogers
My
is
file
on?
shows it was sentenced on 1/12/23, adjudication of guilt, followed by 2 years of probation.
2 years. Okay.
Substance use evaluation, treatment.
Thank you.
And the mental health eval.
Mr. Rogers, listen to this very carefully.
Yes, sir.
I'm not imposing a suspended sentence
Yes, sir.
because I don't want to put a cap on it. Okay?
Yes, sir.
So I don't want to put 3 years suspended sentence on it because I don't want that cap. I want the court, whether it's me or another judge, to be able to sentence you up to the full 6 years in prison if needed.
Correct.
Okay?
I understand.
So don't take any comfort level
Oh,
that I didn't do a suspended sentence.
Yes, sir.
You're adjudicated guilty. You're sentenced to 1 year community control, followed by 2 years of probation. You will need to fulfill all the original terms and conditions of your supervision, but your first 2 years on community control will be drug offender. I'm sorry. So is it community control or drug offender probation?
Well, there's two
different
Your Honor,
kinds.
there's two different kinds. One is house arrest, which is community control, and drug offender would be DOP.
Would
Drug
be
offender
what?
probation.
Probation.
Mm-hmm.
Okay. Forget community control. 2 years drug offender probation.
Yes, sir.
Followed by 1 year of regular probation. Okay. You'll have a 7 p.m. to 6 a.m. curfew. That's subject to being changed for work. So probation can change it for that. All the original terms and conditions, you need to fulfill those, which are substance abuse. You need to do that within 30 days from today.
Yes, sir.
Begin any treatment within 60 days from today. That's
Yes, sir.
huge.
Yes, sir.
If you don't do that,
I
and you come
understand.
back before me, it's going
I
to be a real
understand.
short sentencing.
And the mental health eval.
Yes, sir, and the mental health evaluation within
Correct.
30 days from today, and any treatment if it's recommended within 60 days.
Yes, sir.
Okay? There's a $100 cost of prosecution, $150 public defender's fee.
Okay.
I wish you the best. I want you to succeed. Society does.
Thank you, sir. And since it's all still the same cost of supervision that's waived, and I just have to add another 130 or whatever.
It's $250 is a flat fee that you pay over the whole time.
Thank you. Thank you.
Okay. Thank you, sir. Good luck to you.
God bless. Thank you.
Yes, ma'am. Current supervision is revoked and terminated, and that's it.
Your Honor, this is Ms. Richardson. We do have an agreement to resolve this case. At this time, Ms. Richardson would be entering a no contest plea as charged. The agreed upon disposition is that she will pay court costs, $150 in public defender fees. The state will take no action on any failure to appear and will be withhold adjudication.
Okay.
May I approach?
Yes, sir. Ms. Richardson, if you'll raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Ma'am, you can put your hand up. Ms. Richardson, did you read the plea agreement?
I did, yes, sir.
Do you understand it?
Yes, sir.
Did you sign it? Did you sign it?
Yes, sir.
I do accept your plea. Adjudication is withheld. You'll need to pay the court cost, $150 public defender's fee. How long will it take you to pay that? How long do you want to pay it? 6 months?
Yes, that'll be
Okay.
sufficient.
If you fail to pay it within 6 months, it'll go to a civil lien or judgment. Okay?
Yes, sir.
Thank you, ma'am. Good luck to you.
Thank you.
Last inmate, for the 130 is Jose Vernon.
Mr. Morrow.
Good afternoon, Your Honor. Ryan Morrow from Mr. Jose Briones. We did come to an agreement with the state. The agreement contemplates that we'll reinstate and modify the probation, modify and include Keaton as a requirement, bars to beds, $100 VOP fee, $150 cost of defense, and all original terms will be reimposed. I'm going to put pen and allow Mr. Briones an opportunity to sign.
And Your Honor, for the record, this is a downward departure for the purposes of a legitimate and unforced plea bargain, and the state will provide a score sheet once we get back to the office.
Good. Thank you, sir.
Yes, sir. Yeah, they're just going to wait for the judge's order. I thought we were going to have to come back in June, so I'm glad we got it done. It's going to save you a lot of time.
Yes, sir, please. You'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Briones, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Briones, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated and modified so that you'll need to enter and successfully complete the Keaton program. It'll be a bars to bed, so Keaton will come pick you up and transfer you over there. You'll need to pay the $150 public defender's fee, $100 cost of prosecution. All the original terms and conditions are reimposed, and it is a downward departure because of the plea agreement.
Thank you.
I wish you the best, sir.
Thank you, Your Honor.
Yes, sir. Thank you.
I have Eric Marquez, Mr. Elliott.
Thank you. Your Honor, I contacted Mr. Arrowwood's office because I
Okay,
was
why don't we wait for him? Okay. This is 19 CF 1687. Good afternoon.
Good afternoon.
Okay, yes, sir.
I had contacted Mr. Arrowwood's office when I saw that this was on the docket this morning because I understand that Mr. Arrowwood is still dealing with a lot of health complications. They notified me that Mr. Arrowwood would not be present for court today, and I really need to review it. That's really all the light that I can kind of shed. I know that Mr. Arrowwood was hospitalized the last time that I had spoken with his office. I think that still might be the case. He is dealing with a lot of medical issues. And so I think the state would have no issue continuing this case for a month to give him time to recover.
Okay. Mr. Arias Marquez, Mr. Arrowwood has been in front of the court in numerous different cases.
Yes.
But you're incarcerated, so it's a little different. You've hired him as your private attorney. You know, it's up to you what you want to do as far as that relationship. I mean, I can easily grant the continuance and see you back here no later than June 12th, which is the first date that I have, if that's what you want to do.
Yes, I would like for him to represent me.
Okay.
For June 12th. Well, I got a plea deal on my felony probation, but it was a failure because I wasn't able to.
Wait, don't say anything that'll hurt your case, okay? Everything's being recorded. You don't have your attorney here, so I'm protective of you.
Okay.
What is the current offer to Mr. Arias? Have you talked to Mr. Arrowwood about the latest offer from the state?
Well, yeah, he was trying to get a reinstatement.
And, I don't think at this time the state has really made an offer. I haven't had an opportunity to actually speak with Mr. Arrowwood about this case directly with him.
Okay.
But I will make sure to get an offer relayed to him so that he can relay it to his client.
Okay. So unless you object, I'm going to continue it until June 12th. I don't know why we had it at 2:30, but we'll do it at 9 o'clock on June 12th, okay?
Okay.
Thank you, sir. I'll see you there. And on Mr. Hale's case, did I already continue that? Mr. Arrowwood?
I don't,
Tyler Hale?
yes, I don't see
Yep.
it.
Okay.
Is that the date, the new date? 7th, July?
July 10th.
There's a pretrial date, and this is a VOP.
That shouldn't be, should it? Do you want to change that to July 13th?
Yes, Judge.
If you will, that'd be great. Thank you. Okay, from shortest to longest, what hearings do you want to have this afternoon?
We got a DPA to enter with, Mr. Switek.
Okay, yes, sir. Mr. Switek.
I waive a reading, enter a plea of not guilty, and ask Mr. Gomez to appoint me.
And we will ask for the magistrate to check you out for Baker.
Your Honor, I've got Dion Olszewski in 22 CF 3107. We have a resolution with a DPA.
Okay. Yes, sir.
I've asked Mrs. Olszewski to be here.
Okay. How old is Mr. Olszewski?
Pardon me?
How old is your client?
Dion, 19?
8.
8. This is the case where there was issues of competency going forward, and we're going to waive those arguments and enter this DPA.
Okay. Once those are raised, then doesn't the court have to make a determination?
I don't think that we went down that path within the court for it to be, for that necessity to be met, Judge.
That would have been today had we not reached this agreement.
Gotcha.
Okay. In light of that, though, I've asked Ms. Olszewski to sign off on the DPA as well.
Okay. So, Mr. Olszewski, how are you? You okay?
Oh yeah, I'm okay. I just zoned out. I'm sorry.
Yes, sir. So, this agreement, Mr. Olszewski,
Yeah.
if you do the things that are on there, you agree not to go back to the victim's residence. So if you do these things that are on here, you don't go back to the residence, you do a mental health evaluation, you do these things, then what happens to your case? Do you have to come back before me anymore if you do this stuff?
I think the case is over once I'm done doing all that.
Perfect. That's it. So it's worth your time to do that, so you don't have to worry about me anymore, okay?
Yes, sir.
So I wish you the best. I'm really glad your folks are here. They support you. There are a lot of people that stand at that lectern, both juveniles and adults that don't have anybody that's here for them. So I really appreciate your folks being here.
Thank you, sir.
Thank you, sir. Good luck to you.
One issue. He's on ankle monitor. Can we get that removed?
Absolutely. Yes, sir. Does he have to go to the jail to get that done, or where can he?
Pretrial services.
No, it's probably pre-trial, we don't deal with that.
Okay.
First,
So we'll need to go to the rescue office.
check downstairs. There's an office on the first floor.
Sometimes.
I don't know if they're in there right now.
I don't know if they have.
Where's the office?
Off the top of my head, I don't know.
Yeah, it's on the second floor.
Thank you, sir. Thank you, ma'am.
Your Honor, Mr. Gomez and myself have 2 matters on the afternoon docket.
Okay, I'm wondering about Miss Gooden.
Yes, Your Honor.
I think you were seeking to enter a plea, correct? A plea, Ms. Gooden?
I'm sorry, Your Honor? VOP. Yes, Judge.
You're seeking to enter a plea?
Yes, Your Honor.
Okay, please, if you will, if you'll bring me up to speed.
Your Honor, this is Michael Warner, 18 CF 1084. He would enter an admission to the violation of probation. I've spoken with the state attorney. She agreed that if he paid the $951.51 that is owed on this case, that she would agree to revoke and terminate. His parents tried to pay the clerk yesterday. The clerk's office would not take the payment until we resolve the case today. Once we resolve the case today, then they'll take the payment. I understand that there's either a $100 state attorney fee or a $100 prosecution fee on top of the $951.51. And he's in agreement to that.
Okay, and so the adjudication would be guilt?
It's a withhold, Judge, shows that. That's my concern of doing revoke and terminate, because that would require an adjudication. So if we can, say, reinstate for 30 days and automatically early terminate upon payment.
Okay.
Are you in agreement with that, Mr. Warner?
Yes, ma'am.
To keep the withhold?
Yes, ma'am.
So, Mr. Warner, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can put your hand down. And Mr. Warner, my head's sideways because the microphone's on one side, but I know the camera's on the other side, so I apologize.
Yes, sir, it's okay.
So, Mr. Warner, do you understand that if I accept your plea that you're waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you?
Yes, Your Honor.
So, Mr. Warner, I do accept the plea. Adjudication is withheld. Your current supervision is reinstated for 30 days. However, it will automatically terminate upon the payment of $951.51 plus the $100 cost of prosecution. Okay?
Yes, Your Honor.
So when you get out of jail, talk to probation, you're still on probation until that amount is accepted by the clerk.
Yes, Your Honor.
Thank you, sir. Thanks, Mr. Warner.
All right, thank you, Your Honor. And Cheryl, thank you very much.
Judge, thank you, Your Honor, for allowing us to come in today. To be clear, this was something that kind of happened overnight, but to be clear, it looks like from probation that the amount of money that is outstanding is more significant than what's been stated at this point. So we need to make sure that Ms. Gooden, that they get whatever receipts or something, that proof of restitution payments, all of that, all of it goes to, if something else has been paid, that the probation office can reflect that within their system.
Okay, so how much do you think Mr. Warner owes?
It looks like $1,550 just in restitution.
Yes, sir. He owes $651.51 in court costs, $370 in court costs. Then he owes restitution at $1,550.03. He owes the department $65 in drug testing fee and a $550 cost of supervision for a grand total of $3,336.88.
Judge, the state would agree with waiving at least the cost of supervision. My focus is on the restitution more than anything. So if he can at least get the restitution paid, then for the state it would be sufficient to terminate his supervision, as long as Ms. Gooden and her client understand that means that it would go to a civil judgment if the rest of those costs are not paid.
Ms. Gooden, do you understand?
I understand.
Okay.
And agree.
Mr. Warner, so what that means is if you pay the $1,550.03, then that's when your supervision will terminate?
I'm sorry, Your Honor.
No.
Plus the department has a 4% surcharge on that.
Okay, how much is that?
Let me see. I'll have to get out my calculator because I do not do well in math. Okay. That's why I have a probation.
That's why I'm going to turn.
Your Honor, it will be $1,612.03 total, if that includes the surcharge.
Thank you. So, Mr. Warner, if you pay the $1,612.03, which includes the 4% surcharge, if you pay that, then your supervision is automatically terminated. Mr. Warner and Ms. Gooden, we've changed the numbers on you. Do you still want to do this way? Do you want to do something that says that it's reinstated for more than 30 days that gives him a chance? What do you want to do?
Your Honor, to make sure we understand the numbers, because it's different than what we were told.
Right.
$1,612.03 that has to be paid, and then the rest can be reduced to a lien.
Correct. Yes, ma'am.
Or he can get on a payment plan.
For the restitution, you mean?
Once restitution is paid.
Oh, yes, ma'am. Then it's up to him between he and the clerk as far as paying off that. Yes, ma'am. He can do a payment plan with the clerk.
All right. Michael?
Yes, ma'am.
I'm sorry. Mr. Warner, you understand that?
Yes, ma'am.
And you agree with it?
I agree with it. I'll get it taken care of.
That doesn't change your admission to the violation of probation?
Yes, ma'am.
And Mr. Warner, 30 days is going to be enough for that? For you to pay the restitution or have that paid?
Yes, as long as I could enter into a payment plan if possible. Yes, Your Honor.
You can enter to a payment plan on the money that's owed above the $1,612. So you've got to pay. I don't want to set you up for a violation of probation. You're on probation right now for an additional 30 days to pay $1,612.03. If you say, Judge, you increased the amount of money on me, I need to be on probation longer than that, then that's what I need to know.
No, sir, I don't want to be on probation longer, Your Honor.
You understand it automatically terminates when you pay that off. So if he gives you 3 months and you pay it off in a month, it automatically terminates in a month. Am I correct, Your Honor?
Yes, ma'am. Correct. Probation?
Then I would ask to ensure success that he be reinstated for 3 months.
How do you have this work?
And that it automatically terminate upon payment.
Probation?
Your Honor, he's technically on supervision until October of 23. So I don't know that we need to reinstate him for 3 more months. I mean, he's got time. If we just left him, just reinstated him, and then auto early term when the restitution's paid.
I understand, but I think Mr. Warner wants a backstop to probation. I don't think he wants the balance of it, even though it's
well, no, I understand. If we're going to term him as soon as he pays restitution, but if we're going to add 3 months, then it's going to be added on till 10/23. I mean, I'm just saying he's still on probation. We don't need to add any more time to what he's already has.
Gotcha. Okay. Ms. Gooden, how do you want to structure it?
We can just say reinstated probation, automatically terminate upon payment of $1,612.03.
Okay. Mr. Warner, you're okay with that?
Yes, Your Honor.
Okay, so that's what the sentence is. Adjudication's withheld, current supervision is reinstated, there's a $100 cost of prosecution, but once Mr. Warner pays $1,612.03, then his supervision will automatically terminate, and the other outstanding financials will go to a civil lien or judgment. Good. Thank you, sir. Good luck to you.
All right, Mr. Brown, thank you. And thank you again, Sheriff. Thank you very much.
And I'll notify your family.
Thank you. Have a good day, Mr. Brown.
Y'all too.
Thank you again, Your Honor.
Yes, ma'am. You're welcome.
All right. All right.
Mr. Klein?
Yes, we have Gary Caraglior. This is a motion for release from the conditional release plan. I talked to Mr. Gomez. I don't think the state's going to have an objection.
That's correct, Your Honor. I don't see a good faith basis that the state could object to this motion.
Okay. And
We'll submit an order tomorrow morning, Your Honor.
Yes, sir. Thank you.
We have David Nielsen, which is a restitution hearing. I believe Mr. Gomez is going to request a continuance. There's going to be no objection.
Yes, Your Honor, we're requesting a continuance. I spoke with Mr. Klein. He stated there's no objection. We'll get the restitution hearing done. I would like it just a month from now, just so I can have time.
Okay. June 15th at 2:30?
And then I just have two more from the plea day docket. Stephen Spradlin. I don't think he's ever addressed Stephen Spradlin. I don't see him.
What does the state see?
Agents, Judge.
KPs will be issued for him. Has he failed to appear in the past? Should the first appearance judge determine the bond or no?
I'll have to look it up, Judge.
Okay.
It does not appear so. He's out on the signature bond. So,
Okay. So the first appearance judge will determine the bond, and then the second case?
Second case is Raymond Wagner. These are two cases that look like they were transferred from Division 1. Case numbers would be 23 CF 711 and 19 CF 908.
Actually, I thought it was sentenced on Monday.
He was sentenced? Okay.
Good.
Okay, cool. I just didn't know. So that's all I have, Your Honor.
Thanks, Mr. Klein. Have a great weekend.
All right, you too.
Thank you.
Judge, I think that's all I have as well, if I can make the case.
Yes, ma'am. You're leading like a pack.
Ms. Davis.
Yep. Oh, yeah. We had one this morning, Judge, that we do need to make sure that we include on the clerk minutes, that count 2 is a paraphernalia, that it's just a time served.
That was Mr. Nathan Sims. He was referred to keep. We got an email from the clerk that we failed to address count 2, and the state has agreed with that.
So on Sims, count 2 is time served?
Right. And for me, I had raised this with Ms. Davis before we left on Mr. Schaefer. I thought I heard the court announce 6 months. That should have been 8 months. I don't know if I misheard the court or if the court misread my writing, but I don't want to misrepresent.
Okay, and I don't think I've sentenced anybody to 8 months today.
Should have been.
It's tricky 6s and 8s.
Better get it right?
And I went to check to see if the clerk had it on their minutes or if my agreement had been uploaded, but Mr. Schaefer knew it was to be 8 months, and that was Ms. Davis's offer.
The offer had been 9 months, and we negotiated to 8, so.
Okay.
And I thought I heard the court say 6, but I wasn't sure. Ms. Davis says we better check, so.
Madam Clerk? I just don't remember. You wrote, okay, then I did say 8.
You did say 8?
Well, I don't know if I did or not, Madam
I know that I said 8, and she might have wrote down the 8 that I said, and I'm afraid that you read my 8 that really looked more like a 6, and I just want to make clear for the record.
He sentenced to 8 months.
Okay.
Yes, sir.
Understood. Thank you.
And then just so you can get out, there's one more, Mr. Dakota Collins, who's supposed to be here for a VIP evidentiary hearing. Just don't believe that he is.
Who represents Mr. Collins?
Tomorrow.
Ryan Morrow from Mr. Collins, Your Honor. I don't have any information from the court.
So a KPS is issued for him. First appearance judge determine the bond?
Yes, Your Honor.
Okay, yes, sir.
And that is all I have, Your Honor.
Yeah. All of his cases, yes, ma'am.
Thank you.
Thank you, sir.
Just from pleading the offers.
Okay. What do we do? Since we've been working an hour and a half, we'll take a 10-minute recess, and then we'll come back and finish up the afternoon. Thank you.
All right. Court's in recess.
You got to stay now, sorry.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning, so come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Your pick on how you want to handle them.
Well, I wouldn't start with the last one.
That goes without saying.
Yes, sir. To the state, how do you want to proceed?
Your Honor, as far as the insolvency, we certainly leave that at the court's discretion if the court just wishes to address that already, but we'd be ready to proceed on the motion to correct the sentence after that.
Okay, the motion to declare insolvency may be a little longer than y'all think, so why don't we start with the state?
All right. Your Honor, as the court is aware, we're here in Mr. Tyler Clary's case, 3074 CFA. The court did hear a sentencing hearing and a sentence to the defendant on April 10th to a probationary sentence over the state's objection. And at that time, the state indicated that we believed that he should be on a GPS monitor because he did plead to and was sentenced on 827.071. Subsection 5, which is possession of child pornography. It's still the state's position under the probationary statute, which I did attach to my motion to correct sentence, 948.30. which addresses specific additional terms and conditions of probation or community control for certain sex offenses. There are certain additional requirements that are mandatory. They are not discretionary, Your Honor, and that is still the state's position. Does the court wish a copy of those? I did attach them, but I certainly have another copy.
Yes, ma'am, if you will, please, thank you.
Yeah, okay. And actually, I'm going to refer to a probationary order as well, so I'll bring that up to the court. Those are both attached. And Mr. Patel, Mr. Shaw, you have those?
Yes.
Your Honor, I'm presenting the court a copy of the statute 948.30, and also, Your Honor, this is a blank order of sex offender probation that I also referred to in my motion. Your Honor, if the court referred to subsection 3 of that statute, the 948.30, I believe it's found on page 4 of the copy that I gave you. Subsection 3 says effective for a probationer or a community controlee whose crime was committed on or after September 1st, 2005, which this was. Under it states the court, hang on, sorry. As subsection A is placed on probation or community control for a violation of chapter 794, 804, sub 4, 5, or 6, or 827071 and others, and the unlawful sexual activity involved a victim 15 years of age or younger, and the offender is 18 years of age or older, then at the bottom it reads, the court must order, in addition to any other provision of this section, mandatory electronic monitoring as a condition of the probation or community control supervision. Your Honor, it is the state's position, and we believe also probation and parole's position, and I'm also here on their behalf because they did ask me to bring this back before the court, that Mr. Clary falls squarely in that. To get the age of the victim, we look at the age of the images that were charged because those were the victims in the case. And as the court is aware, these were very young victims, so they were clearly all under 15. Also, I provided to the court a copy of the standard order of sex offender probation. And on page 5 of 7 of that copy, under subsection 31, it also states basically the same thing. It reiterates the statute that I just read. And it also says that the court must do that. So we're asking the courts to impose what is required under the statute. We do believe, Your Honor, that there is no discretion for the court on this.
Okay, thank you. Yes, sir, Mr. Patel.
Respectfully, Judge, I disagree. And I want to kind of clear up some of the statements that were made in the state's motion to, may I be seated?
Yes,
thank you, Judge. I want to clear up some of the statements that were made in the state's motion to correct sentence. So, as I understand it, there are 3 ways to attach a GPS monitor to a person that is a registered sex offender pursuant to the Jessica Lunsford Act. You have, and I stated it in paragraph 3 of in the state's motion under 948.063. That statute talks about violations of probation in which the court shall attach the monitor. That's not an issue here. So then the question becomes is what are we arguing about? And so what I stated to the court at the sentencing, I talked about the provision right above sub 3, which was sub 2. And in that part I said, I talked about electronic monitoring, and so now I'm talking about 948.30 parens 2 and parens subsection E. And that statement says electronic monitoring when deemed necessary by the community control or probation officer and his or her supervisor and ordered by the court at the recommendation for the Department of Corrections. Now, when I indicated to the court that I had previously spoken to probation, my conversation said that as it relates to that, probation's position is that they're always going to do it. And that's what I said. So, now I understand that the argument of the state has nothing to do with 2E. It has everything to do with 3. So the state is taking the position that parens 3 sub A applies to Mr. Clear, and I don't think that it does. I have done a significant amount of case law research, and there's not really anything out there as it relates to possession of child pornography and the requirement of electronic monitoring. So that leads me to believe that really what I'm asking the court to do is interpret the statute as the legislature has written it. And I think the court should take into consideration that after it says is placed on probation or community control for a violation of Chapter 794, 800-04 sub 4 sub 5 or sub 6, 827-071 or 847-0145, and the unlawful activity is involved a child, or rather a victim 15 years of age or younger, and the offender is 18 years of age or older. It is our belief that if the legislature wanted everyone on 827-071 to have a monitor, then they would have put that. But they specifically added this language relating to the unlawful sexual activity involving a victim 15 years of age or younger and the offender being 18 years of age or older. So if the court looks at 827-071, which is a statute in which Mr. Clear was sentenced on, there's sub 2, sub 3, sub 4, and sub 5. So his cases were sub 5. When you read subsection 2 and subsection 3, they're clearly hands-on offenses in which the perpetrator is actively doing something involving the sexual performance of a child. Same thing with subsection 3. Subsection 4, not so much. It appears to be a hands-off offense. Subsection 5 is very much a hands-off offense. There is no contention that Mr. Clear was in those videos that he pled to and was sentenced on. And the state can't sit here and say that he was, or really there is no evidence at all presented in this case that that Mr. Clear was in those videos and that he was over 18 years old at the time of the offense. So our position is simple. This statement, when the court looks at the required and to get to the requirement of the adding of the mandatory monitor, it doesn't apply to 827-071 subsection 5.
Tell me that again, 827?
071 subsection 5, which is what Mr. Clear has been sentenced to.
So why isn't that included in the statute just because it says 827.071? Why wouldn't that be all of the subsection?
It could be, except for the fact that it talks about the unlawful activity of a victim 15 years of age and the offender's 18 years old of age or older.
In the statute or any authority that defines sexual activity?
No, Judge. I'm looking at 827-071. It's got a lot of definitions. Sexual activity is not one of them.
Do any of the other chapters have a definition for that?
I haven't looked at every chapter, but I'm willing to get on Westlaw right now and start looking.
Because you're arguing that sexual activity doesn't include child pornography.
Well, it says that the offender is 18 years of age or older in that same situation. That's not what we have here. He's not in any of those videos.
But it doesn't say in a video, it says sexual activity, right? Isn't really the dispositive portion the definition of sexual activity?
But the crime here is possession of child pornography. So in that pornography, the allegation would have to be, in order to make this work, that Mr. Clear would have to be over the age of 18 in those videos.
No, it just requires the offender to be over 18 years old.
Well, he's the offender.
Right, but it doesn't say anything about videos or anything else in here, it's a sexual activity, and he is the over 18 years old.
And Judge, I think the issue, to me, the issue is that there's such thing as hands-on offenses versus hands-off offenses.
That's not in the statute, though, right?
No, but when you look at the statute, when you look at 827.071, clearly there's 4 crimes in there. The first 2 crimes are hands-off on offenses.
Well,
the latter 2 crimes are hands-off offenses.
The statute 3A has the whole chapter in there, or the whole section, 827.071, which would, unless there's something that says, I mean, it wouldn't make any sense that it doesn't include any subsections. The court would be redrafting the statute if I said it's only these subsections and not other subsections.
Judge, and Tim Shaw, I think what the argument is from the defense, Your Honor, is, and I can follow what the court's saying, to the extent that there is not the and the rest of the phrase. Okay, so if it just said, as the court just mentioned, it is placed on probation or community control for a violation of Chapter 794, 800 for blah, 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 827.071, 847.0145, and stopped there, I think the court is absolutely correct.
Conjunctive in adding and the unlawful sexual activity. That's why I'm asking for the definition of that.
Right. And if the legislature had intended for each one of those sections of 827.071 to apply, they wouldn't have put and the unlawful sexual activity involved a victim. And since the legislature didn't specify that, the plain reading is it does require that, and the sexual activity is not defined. Therefore, it's our belief that sexual activity requires a hands-on offense as well.
Okay. Let me ask you this question. Is there any problem with double jeopardy, with me changing the sentence at this point and adding a GPS?
No, Your Honor, because this would have been required, frankly, regardless of whether or not the court announced it. It is a direct consequence of the plea and of the sentencing, or of the court, what the court sentenced him to. So those are mandatory conditions. And also, Your Honor, I would point out to the court that this was actually heard by the court in the Adley Cohen case with Mr. Swiatek and Ms. Barrickman back in last July on case number 21-1584, and the court did find that it was mandatory there, and it was the same type of charges. And that was also brought to my attention by probation, who actually dealt with that case. But, Your Honor, this would have been imposed regardless of whether or not it was orally imposed by the court by statute. And that is really why it was such a concern for probation and parole, because they felt like, listen, our hands are tied. We got to do this. So we wanted to bring it back to you.
Yes, sir. Mr. Clear, I can't ask you to follow the law if I don't follow it. I understand that we disagree on what the law is, but without a definition of sexual activity specifically within the chapter 827, then I think that the sexual activity is talking about the activity that happens within those sections of the different statutes. I can't, and even when Mr. Shaw argued, he said, and, you know, sexual activity and hands-on. I can't add and hands-on to the statute. So,
Judge, before you pronounce it, I have a supplemental argument, even if the court was to impose GPS.
Okay.
I would ask the court to consider 2 facts. One, at the end of 3, apply A, B, or C, and then it says the court must order, in addition to any other provision of the section, mandatory electronic monitoring as a condition of probation or community control supervision. It does not say for the entire period of probation. And so Mr. Clear is trying to transfer his supervision to Oklahoma, where the rest of his family is. His probation officer that's handling that the transfer investigation is here. We would simply ask that if the court is inclined to impose GPS, that we impose it while he's residing in the state of Florida.
Is there any authority that says it's not for the entire term?
No, Judge, there's not. And again, I'd point to the plain letters of of the statute.
Mr. Clear, I know that this is probably going to cause you all kinds of problems, and we may have to deal with that in the future. But at least for the hand that I'm dealt today, the motion that's been filed by the state today, I have to follow the statute, and so the court does impose a GPS monitor for the entire duration of your probation.
Thank you, Your Honor.
Yes, ma'am.
Thank you for allowing us to bring that back to you.
Yes, ma'am. Okay. So back to what you probably thought was the easier of the two,
Clearly I was mistaken.
Which is the motion to declare defendant insolvent has
Just appeal that issue too.
has the Justice Administrative Commission been put on notice of this hearing as required by 27.52? Mr. Patel or Mr. Shaw? It says indigent for cost. Doesn't that require under 27.52 parens 5 parens small b as in boy, person shall arrange for the service of a copy of the motion and attachment on the Justice Administrative Commission? It's easy to think that this is just the same thing as appointing an attorney, and it's probably because it comes out of different pockets. If I appoint an attorney, the Public Defender's Office pays for that. For payment of costs, I think the Justice Administrative Commission has to pay, and so I think they're put on notice. They need to be put on notice of this and see if they object to it.
And Judge, at this time, I'd like to continue the hearing. I have not done that, so I will. Judge, Mr. Clear was able to arrange for a ride today to get here. I would like, well, he's not supposed to use electronic devices, but the Supreme Court has allowed use of Zoom appearance to be present for certain proceedings. Is the court inclined to allow him to appear by Zoom in some manner for this next hearing?
Any objection, Ms. Basso?
No, Your Honor, not to that, no.
Yes, sir. Certainly he's granted that. Just look at that statute because it says, and I don't know if your motion has all these things in there, but it says the motion, he must have completed the application, for a public defender, an affidavit attesting to the estimated amount of attorney's fees that y'all have charged. I don't know if y'all are ready to, give evidence on that. Just know when you come back, that's what you got to do. Put the JAC on notice of it. There's a presumption in D, in 5D, that says if the attorney's fees exceeded $5,000, then there's a presumption, I think, that you don't prevail. And so what do I have to do to rule in favor of one of the parties? So just make sure that you fulfill that statute, okay?
Thank you, Judge.
Thank you. So do you still want to withdraw? Are you going to
no, because we got to get this done first.
Yes, ma'am.
Honor, probation has asked that Mr. Clary be ordered to report to probation to have that GPS monitor fixed.
Yes, ma'am. So you need to do that immediately, okay?
Yes, sir.
Thank you, sir.
Thank you.
Thanks, y'all. That's it for that hearing. And
Yes,
then there's
Judge.
some other things we've got to do.
Thank you, Judge.
May I be excused, too?
Yes, ma'am. Thanks, Ms. Foster.
What's that?
I need to talk to you about that.
Okay, Madam Clerk, you got it. What are we talking about? Mr. Gonzalez? Mr. Gomez, we're talking about what's left on the docket.
Talking about trail running over here, sorry.
I have Joshua Marshall.
I believe he was a pro se that did not appear, so.
Yeah. You should be fine. That was a great appearance.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of North.
Unless I say otherwise, it'll be the first appearance.
Then I have Jason Morrison.
First appearance? Is that
Your Honor, if I'm not mistaken, and I could be wrong, I believe, and it is now the second time this has happened this year since I've been here, but we're not really getting notified if they get picked up based on that out-of-state warrant. I think the only thing that I can really do is look in the jail when I see that I have an out-of-state fugitive and see if they got released. I know that Mr. Morrison was released, and I can't imagine that we would release somebody who had an out-of-state warrant pending, so I'm assuming that that state came and got him. And so given that, the state would dismiss this case, because that's generally what we do whenever an out-of-state defendant
So you're
gets picked
dismissing
up.
that case?
Yes, Your Honor.
And that case is dismissed.
William Troy Bordenbaum.
What was the last name?
Bordenbaum.
Your Honor, if they have not appeared, we would request a capias.
Capias will be issued for him.
And then on felony day, Jonathan Ernest Wilkinson.
This is on PM, right? I'm sorry.
It's felony for felony day.
Raymond.
Your Honor, if they have not appeared, we would request a capias.
Capias, yes, ma'am.
That's all I have.
Okay, great. Thank you, Madam Clerk. Thanks, everyone. Thank you, sir.
Thank you, Judge.
Thank you.
Doing well, how are you?
I'm doing well. How are you?
Doing good.
Waiting for the bailiff to start getting his stenographic machine. Are we going to start doing that? No. Good. Thank you. Thanks, Mama. Good. That's great. It's neat.
I did not sign no public release of your. I hate.
It is funny because I started in the morning. I'm counting for only a couple times on traffic. I thought, so we're still in and the defendant said, I didn't know that trip. That was like, they said, I didn't know it was Delaware or and the officer saying,
I don't like that.
He spins around and says, is that you?
Like each time you
Maybe is that you? See that line? It's really nice. It's just a little light. I don't think you can see it. I don't think you can see it. Well, they didn't then. He just spun it around his laptop. That was before Zoom and everything. So maybe they stick it on there. But it was fun. That's good. That's good. No, that's good. Society even know what's going on. It's good. You gonna do trials? Hey.
We got some next week. Or the weekend.
We have.
Every time you schedule one, they.
Ours are going away.
Yeah, at least one. At least. Yeah.
You got one coming up this month?
I think I will.
Good.
But I do know for certain that there are others this cycle that are going to
Answer your question, absolutely positively, I will do trials if I'm allowed. And I'm not saying not allowed by you, but if it's a prestige trial, I probably won't be able to do it. But just like it, I'm just half-day trials.
And those pick and goes are, they can get close. They can watch the whole thing. That's what I tell when people say, I want to come see what's going on. I go, do a pick and go but come even for the jury selection because people just don't realize, especially in civil and criminal, how much information is given to the venire before they're even seated.
Right.
It's really neat. It's really interesting. Just got to be really careful about the jury, careful about audio from the defendant talking to their client.
Yeah.
Those are
What we discussed on the picking goes, because they have so fast, the jury's picking and they're gone, is I'll be set up a third row back, I can leave my stuff out in the hallway. I probably won't bring multiple cameras. I'll just do one camera. I can be set up in about 10 minutes. So if there's a lot of discussion between the jury selection and the trial between the state and the defense and the judge trying to figure out last minute things, I'll
Gotcha.
Cool.
Thank you, noise.
That works. Have a good afternoon.
Thank you, sir. You too. Carl, that mic still isn't great. Carl? Not great. Speaker over there, maybe?